Greetings, ladies and gentlemen. It's exciting to be back with you and also to be joined by the wonderful Miss Seema, who is gracing our live for today. Thank you, Seema. How are you doing?
I'm doing well. How are you?
Doing great. Thank you so much. I appreciate it. Appreciate it. So we are essentially going to be thinking about the sort of pathways that exist for EB1A and national interest waiver and other ways in which folks can go around this menacing backlog that exists. There's so many millions of people now who are suffering in these backlogs. And what we're trying to do is find pathways for them where they do not have to be subject to a never ending backlog and can find a pathway to liberate themselves of these situations. So that's sort of what we're thinking about today. And hopefully we can kind of have that conversation. And one of the reasons, Seema, I wanted to have this conversation with you is recently you wrote a blog piece about, particularly about EB1A, which is, for most people out there, they understand the first category immigration, and particularly as it related to the salary piece. So within the context of EB1A, while there are statutory requirements and we always look for a final merits determination in a holistic fashion with regard to how the individual meets that requirement, there is a lot of value in thinking about salary and how that might impact one's case. So what were your thoughts basically that you had written and thought about in terms of salary and how that might help the cause with regard to EB1A and how do you think we could advance that further?
Yeah, I mean, that's a great question. So for salary, USCIS, especially when it comes to EB1A, USCIS doesn't have any specific dollar amount. So in terms of salary, I would say USCIS is flexible. And for major business-related EB1A, if the individual makes over 250K, for vast majority of professions, we can meet that salary requirements. So when it comes to EB1A, and especially that salary criterion, what matters is that the salary should be significantly higher compared to other individuals in the same field. So, but it's also important to make a right decision about what title we want to choose for that individual. Because a lot of clients think that when it comes to EB1A, the title we choose for the EB1A application, it should be exactly the same as their EB2 or H1B, but that is not correct. So when it comes to EB1A, your title should reflect and should be tied to your field of endeavor.
Yeah, that's such an important point. I think, a lot of people miss that because, when we're thinking about an EB1A case, we're thinking about a self petition. And a self petition is not always about exactly what you're doing right this moment. So, I've had cases in the past where, for example, an individual was an antenna engineer working in Europe, where they were creating sort of solutions for the cellular antenna type scenarios, and then they got a job with a consulting firm. They came to the U.S., and when they were working in the U.S., they were working in a completely unrelated field. They were like working because that was the only job that they could find that worked with the H-1B application. But when we submitted the case for them, their field of endeavor and the purpose of their EB1A was all about their life as an antenna engineer prior to coming to the US. They had only been in the US for a couple of years, and they were among the most, important and, well established professionals in this space in Europe. And then we were able to, get their EB1A done. And, we didn't even pay any attention to what their current job was, what their H-1B role said, what their salary was in the United States. The entire case was about the role that they played in Europe. So I think
Exactly.
that's an amazing point that you bring up with regard to folks tend to think that they are really limited by their past or their, I'm sorry, current visa status and what their maybe perm application said or what their H-1B said for the purposes of identifying their role within an EB1A context or even a national interest waiver context, where you're really thinking about what is your proposed endeavor or what is your in a context of EB1A claimed area of extraordinary ability. So I think that's really an
Yeah.
excellent point.
No, I definitely agree with you. And the reason why I brought up that title for EB1A is because the salary, at the end of the day, the comparison we make for salary part of the EB1A petition is going to be based on the title we choose. And so that's why it's very important to choose the right title. And usually when we do comparison, first of all, as I mentioned, there is no specific dollar amount, but the person should make significantly higher than 90% of the same individual in the same field.
Yeah.
So it's really important to like tie the right title to the right salary. And for
Absolutely. Yeah. So
EB1A,
you want to show you just to be clear, what we want to show is that one is making higher than a high salary. So if you're like, for example, looking at a chart, something like Department of Labor, or even a private survey, and it sort of indicates that at the 90th percentile, one earns maybe $150,000. You want to demonstrate that you're higher than that high. So
exactly.
that's sort of when we think about a relative comparison, that's going to be what we're looking at. And just one other note to add here is I think that there is a tendency to be limited in the thinking as it relates to salary. And one of the things that I really liked in your article was that you mentioned things beyond only relying on W-2. So we know that a W-2 is, probably the best form of documentation that demonstrates salary. But then you also mentioned other forms of documentation that could be used in terms of salary.
Exactly. Because sometimes for a lot of clients, usually they have one W-2 for each year, but sometimes they get promotion within the company or salary increase. So what we ask them to provide us is employment verification letter, because sometimes W-2 is not going to reflect the clear salary they're making right now. And we need the highest salary. And let's say somebody got promotion recently, so we need to get that employment verification letter that shows the compensation that the individual is making. So it's important to note, like, W-2 is not the only document we can provide USCIS.
Yeah, because if you think about the plain language meaning of the statute, what it's saying is that one demonstrates that they command a high salary or significantly higher remuneration, right? So the word or the operative term here is command. So if one commands a salary, it doesn't necessarily mean that they have already earned a salary, right? So beyond like letters of verification and W-2, one of the other things that was mentioned there was the job offer. So I think that in that regard, we could definitely find that folks could be in a situation where their cases would be maybe more likely approvable than they even realize, simply based on the fact that they're able to get a job offer. Because a lot of folks that I've met and discussed are able to get job offers that they can't even accept because of their immigration situation. And when we think about command a high salary, it's really that you would command this salary if you're essentially operating on equal terms. So that's going to be a really important aspect that people need to understand. And one of the reasons why I think folks should reach out and have an evaluation of their case done is to see not only are you just, basically, there's, I've always been against this kind of like template approach of saying, do you have these documents? Do you check those boxes? Because I think if you take a unique approach to each and every case, you could kind of tailor that messaging and tailor the individual's documentation to meet those statutory requirements, regardless of whether or not they are met on the surface. And I've seen, again, many instances where an individual might have a W-2 that's relatively normal in terms of the salary. However, they are able to get a job offer that's exceedingly high. So those are some things that really could help a lot of people that maybe don't realize that those opportunities exist while they're sitting there on a backlog and trying to find a new or a different pathway to a green card that overcomes this backlog. I think that you nailed it with regard to the discussion about salary and finding a way to go about demonstrating to the adjudicator that they meet that very high standard. So thank you for that. That's excellent.
Thank you.
Absolutely.
So yeah,
ahead. I was just gonna say I do want to share stuff about visa bulletins, but before we get into that, if you have other questions or thoughts.
No, actually, that's a great point. The visa bulletin and recent backlog, because as we are moving through 2024, one of the most pressing issue in the U.S. immigration is the growing number of backlog, both for employment-based visas, EB1A, EB1, EB2, EB3, and also most of the family-based cases.
Absolutely. Yeah. So let me just pull this up on our screen here, and hopefully you all can see it. So, the most recent bulletin was recently brought forward, and that is for the upcoming month of September. So these are the dates that were given as it relates to the September bulletin. So I'm going to skip the family sponsored preferences and, just kind of discuss the employment based preferences for us. So right now, the final action dates for employment based preferences are, obviously for all countries besides India, China, Mexico, and Philippines. First category, so EB1, and that would be true for EB1A, which is extraordinary ability, EB1B, which is outstanding researchers or tenure track professors, and EB1C, which are multinational executives and managers. So all three of these subcategories within EB1A are all considered, within the EB1 classification are all considered first category. And there you find that all countries are current within the month of September, except those listed. So the ones listed, mainland China, India, Mexico, Philippines. Mexico, Philippines are current for first category. And then you do have a backlog for India and China. So for India, February 1st, 2022. What that means is if you have an EB1 petition that has, you have an EB2 or EB3 petition that has already been approved, and you have a priority date that comes before February 1st, 2022, then we can leverage that previous priority date. We can port it in an EB1 scenario, and you would be able to immediately adjust status. Or those of you who have already submitted EB1 successfully, you would be able to adjust status based on that February 1st, 2022 priority date. So that is actually looking better than I thought it would. I mean, normally when we're looking at the last month of the fiscal year, it does tend to retrogress back. Like last year, for example, EB1 retrogressed like 10 years because they just said, nobody submitted any more applications. We're not going to be able to process them. However, this year, there is some overflow, and they have maintained the EB1 level at February 2022. Of course, we'd love for it to be current for both India and China. However, relatively speaking, compared to last year, this time, we are in a much better situation. The second, and just so you know, like in relation to the filing date, it's the same date for India. So February 8th, 2022, and all other countries current. So it's the same thing with respect to filing date or final action date. And I'm going to go into that in just a second. So and then the other, I think, really important information that's out there right now is the March 15th, 2023 date for EB2. All countries, so those of you who are self-petitioning national interest waiver clients and you're from any country besides India, China, Mexico, Philippines, although Mexico, Philippines share that date, then you're looking at March 15th, 2023. And you see the backlog for India. It's really not getting any better in the EB2 category, and that's why we're having this conversation. It's really, really terrible, horrible, horrifying, because the number of people between July 15, 2012 and present, it's just ballooning, and there's no end in sight to folks who, have priority dates in the, maybe 2015 and higher, even 14, I think, we could say it's really, really bad. So those things are going to remain, pretty much where they are. We'll see what happens. I mean, of course, the big State Department bulletin is going to be October, because that's the first month of the fiscal year. I'm anticipating some advancements, particularly in the EB1 category. We'll probably see India as current, and second category, all countries, we're likely going to see current, and we'll see what happens with India EB2. But I wouldn't hold my breath. I think it's more important for us to figure out some ways in which you could take matters into your own hands and find a better pathway toward, getting out of the backlog and into a green card, particularly by leveling up your case from an EB2 to an EB1 and making sure that you're putting yourself in a better situation. Now, I am going to point out the reality that although this is listed as final action date and this here is listed as filing date, that terminology refers to individuals who are filing their case in a consulate abroad. So those are terms that are State Department consulate terms. Anyone who is physically present in the United States, you need to understand that this State Department bulletin does provide the basis for the information, but ultimately what will determine your ability to file for a green card, your ability to, file for adjustment of status, will not be the visa bulletin. It will actually be the adjustment of status bulletin. Now, the adjustment of status bulletin, it's when to file your adjustment of status. Now, this is based on the State Department bulletin. However, the reason why I point this out is because there are months that USCIS uses final action date, and there are months that they use filing date. And when those dates are different, you need to pay attention not only to the State Department bulletin, but you also need to pay attention to the USCIS filing adjustment of status filing chart. So they have not yet released the filing chart for September. Although State Department has released final action dates and filing dates, USCIS has not yet indicated what they are going to adopt. Excuse me. They have not indicated what they're going to adopt for the month of September. For example, in the month of August, as it relates to employment-based cases, they adopted the final action date. That means if your final action date was current in the month of August, you're able to file for a green card, for adjustment of status. Interestingly, within the family-based category, they adopted filing date. And this means if your filing date was current as of the month of August, within the family-based categories, you're able to file your I-485 adjustment of status, and it will be processed. You'll even be issued a green card if the processing is completed. There is no controlling factor of whether USCIS is using filing date or final action date as it relates to the processing of your green card. This is only a choice that USCIS makes as to what they wish to use as the basis for adjustment status, based on demand, based on pressure, based on availability. They make a determination. We will use filing date so that we can give more, we have more availability, we have more ability to process, or they'll use final action date if they want to slow things down. So right now within the employment based side, they are slowing things down a bit by adopting the final action date. Within the family based side, they are being more liberal in allowing the use of filing date for the purpose of adjustment of status. So please understand, if you're in the United States, the controlling date is what is provided under the USCIS when to file your adjustment of status application for family sponsored or employment preferences. Right now, this is for August 2024. They have not yet released September. Okay, they have not yet released September, so we're waiting to see what happens. But you can, definitely keep checking. So if we check here, it's gonna, still say dates for adjustment right here. See, adjustment of status filing charts. So dates for filing chart. This is still Department of State bulletin. Oh, actually, they're saying, okay, so for September, they've already declared for family-based preferences, you must use data filing chart. And for employment-based preference, you must use the final action date. So they've already made the determination for September as well. But again, they're the same date anyway. But I just want you guys to understand the policy and understand what to look for in future months. So you always want to double check this, because this is not always the case. Some months you'll see that employment-based preferences will say you must use date for filing. It's not always going to say you must use final action date. So you can double check, because I've seen people miss opportunities to file for their green card just because they misread the bulletin. So I want to make that very, very clear so that folks have the information that they need in order to put themselves and their families in a better situation. So that's exactly what we're seeing here with regard to the visa bulletins, and one of the reasons why these backlogs continue to linger and be such a burden on families and workers throughout the country. So unfortunately, it's something that we're going to continue to see, but hopefully we can overcome it step by step.
Yeah, I mean, I agree. Especially one thing you point out was like, when it comes to EB1, we have a lot of clients from India and China where the employer filed for EB2 or EB3. And the good news is, if they are working for those big tech companies, and if they are already making critical contribution as part of the company or making such a high salary, they can upgrade from EB2 or EB3 to EB1. So that way, as you've mentioned, a lot of clients have a previously approved I-140, and then what we can do is we can port that priority date and we can file for adjustment of status. Plus, if they do self-petitioning for EB1A, they have a lot of freedom, and their immigration status is not tied to a specific employer.
Exactly. Yeah, that's perfect. I think understanding that folks who are out there in the high levels of profession, whether it's in the technology industry or engineering, medical fields, we have seen great success across many industries. and those individuals who are, contributing at a very high level. And we know for a fact that many of the highest level contributors in the United States right now, whether we're talking about semiconductor industry, whether we're talking about technology, software, artificial intelligence, all of these major growth areas are heavily, heavily filled with people from other countries, particularly India and China. And we have seen great success in moving those individuals from the EB2, EB3 categories to EB1 category. So that's the situation. And so I'm just looking some of the comments that came in. Folks are wondering, if their priority date for EB2 is able to be moved into EB1. And as Seema noted, of course, you can port any previous priority date that you have within an EB3 or an EB2 can be moved into EB1. And the good thing is, even let's say, God forbid, your case didn't work out, right? That you tried to file for EB1 and for whatever reason, things didn't work out for you. And after maybe some efforts, the case was ultimately denied. It does not change your situation with regard to your previous EB2 approval. That approval remains. Like, you're basically in the worst case scenario already. The fact that you filed for EB1A does not, detriment you in any way as it relates to your case. So it's important to give them ability to file. So I think they indicated that their date is June 2023. So that date is not current for EB1 at this exact moment. My prediction, though, is that that date will be current in the coming fiscal year. So I think that person would be if they had an EB1 approval, they would be looking at ability to adjust status within the next several months.
Exactly. And I think with the premium processing, USCIS usually, because a lot of time we file with premium processing and we request USCIS to port the previously approved EB2 or EB3 date. And the good thing about the premium processing is USCIS adjudicate the I-140 within 45 days, which is pretty fast in terms of the
Yeah.
system.
So in fact, premium processing for EB2 national interest waiver is adjudicated within 45 days, and premium processing for EB1 category is adjudicated within 15 business days. So 15 business days can mean 3 business weeks. I have seen, for the most part, is 2 weeks is what they normally take. But yeah, they do have 15 business days to do the the filing. Now, I do want to say one thing about national interest waiver, which is those individuals who are on a employment-based perm, even if you're in a backlog right now, and you're not quite ready to start thinking about EB1, it might be useful for you to leverage an EB2 national interest waiver for a couple of reasons. Number one, when you change employers, the new employer is going to have to file a new perm for you. And in our current economic situation, even if you have a strong economy, one thing that you definitely see is a lot of changes in people's job roles. So, for example, it's rare that an individual performs in the same kind of like role for 5 years or something like that, right? So it's always every year they're getting a new title, they're getting a promotion, they're moving to a, maybe a different aspect, or sometimes, they start out as a database engineer, and then next thing you know, they're a data engineer, and the next thing you know, they're an AI related engineer. So things are changing quite quickly. So I think having an EB2 national interest waiver is something that will give you security, such that you do not have to depend upon your job or your employer for your future green card, or even like to renew your H-1B. And the other thing that we're seeing is those individuals who are just getting their perm filed, the perm is taking forever. I mean, perm is taking, I've seen 3 years, 3.5 years. It's getting quite ridiculous in terms of the wait time that is going on with regard to the perm application, whether it's because of Department of Labor delays, USCIS delays. Therefore, I think it's really, really important that the individuals who are thinking about just continuing in their EB2 pursuits, consider a national interest waiver, EB2. There is USCIS policy memorandum that favors STEM related categories for those individuals who have STEM degrees. So I think it's really important to think about that national interest waiver in addition to EB1 as a tool to combat this backlog. So those are just some sort of relatively important thoughts that I wanted to share with folks out there. Anything that you wanted to add before we wrap up, Seema?
I see comments from folks that if they file their case next year, EB1. Well, I mean, as attorney mentioned, there is no guarantee that the cutoff date for visa bulletin for EB1 will be current for Indians, but because October is a new fiscal year for most of agencies, including USCIS, we are predicting that EB1 category, the cutoff date will be current. So yeah.
Yep. But we don't know how long that'll last though, right? Because if it becomes current or, close to current in the month of October, that may continue maybe through December, January, February, things might start to slow down, and then into the, fall and summer, things do tend to change. So it's always good to, take action sooner than later. And the other thing is it's really important, I think, to consult early if you're thinking about an EB1A, because there's a lot of misinformation out there, and people tend to maybe just listen to whatever flavor of the month is there, and they might waste a lot of time doing things that are not actually going to help their case. So it's a really good idea to consult. You can check us out at silmilaw.com and schedule a consultation. But thank you so much, Seema. It's been really a pleasure to connect with you here and to share some useful and helpful information for folks out there. And everybody, thank you so much, guys, for tuning in to YouTube and some of the other platforms that this is appearing on. We look forward to connecting with everybody, and always check us out on our website for more updates and details, silmilaw.com.